their presence, and we'll go for, does the defense have a motion?
Yes, sir. So, move for a judgment of acquittal again. Your Honor, we renew that motion. No reasonable jury would be able to find Ms. Jewell guilty of count 1, 2, or 3 after the close of our. First, we have culpable negligence. Just pointing out the jury instruction says if there's a violation of that duty, referring to the duty of care, everyone, without any conscious intent to harm, that violation is negligence, not culpable negligence. During the state's case and our case, it has been presented that this was a conscious harm, Ariya. So, culpable negligence proven. I know that the state previously cited Taylor v. and Lee v. State in their last argument for a motion. In Taylor v. State, it's a woman tested positive for meth in the hospital. She was instructed with the baby in the bed with her. She knew the keeper when she used meth. She used meth the night the decedent passed away. She also chose to sleep knowing that she was a heavy sleeper. She woke up throughout the night, never knew the child was dead. That shows conscious intention. Similarly, Lee v. State, the defendant was dating the mother of a child. The defendant knew that there was an against the mother for beating the child. He signs of abuse, made the conscious decision to ignore those signs and not report them. His choice there. The jury instruction indicates consciousness or intention is required. The state has presented no evidence to support that this was a conscious decision.
I appreciate your attention. The defendant has been charged with 3 different offenses. First one was aggravated manslaughter of a child. Second one was third-degree murder, not premeditated during a felony. And the third one was leaving a child unattended or unsupervised in a motor vehicle with great bodily harm, or as in this case, death. I want to go through these counts in a little bit of detail, and there are lesser included offenses as well, so I want to go through that. The state, in order to prove aggravated manslaughter of a child, has to show 3 things. One, that Ariya Page, the victim in this case, the 10-month-old infant, is unfortunately deceased. She is dead. We have proven that. Number 2, the death of Ariya Page was caused by the culpable negligence of the defendant, who is seated in the courtroom today. I want to tell you, the court's going to tell you later during the jury instructions what is culpable negligence. The judge is going to read to you a bunch of instructions, but I want to tell you just a small portion of it. Culpable negligence means that every person has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence.
Cannot be guilty of aggravated manslaughter by causing a death because of a merely negligent act. Culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. We do not have gross and flagrant negligence here. What we have is an accident. Rhonda Jewell forgot the baby. You don't look at the outcome. You don't look at the fact that Ariya is deceased to determine whether negligence is gross and flagrant. You look at what happened. What was the negligent act? The negligent act here was that baby was forgotten in the car. Forgotten, not consciously done, not culpable.
Ms. Jewell, would you and your attorneys please stand while the verdict is read? At this time, I'm going to ask the clerk to please publish the verdict.
In the Circuit Court of the 8th Judicial Circuit, in and for Baker County, Florida, State of Florida versus Rhonda Jewell, case number 02-2023 CF 333. We, the jury, find as follows as to count 1 of the information. The defendant is not guilty. We, the jury, find as follows as to count 2 of the information. The defendant is guilty of third-degree felony murder as charged in the information. We, the jury, find as follows as to count 3 of the information. The defendant is guilty of leaving a child unattended or unsupervised in a motor vehicle causing great bodily injury as charged in the information. So say we, this 8th day of November 2024, at McClenny, Baker County, Florida, signed by the foreperson, David Saints.
Very good. Be seated, please. Is either counsel aware of any further proceedings that would require the presence of the jury?
We'd like to have the jury polled, Judge.
Okay. Anything else we need to do at this point?
No, sir.
Okay, again, to everyone, thank you very much for your participation in the process, and we are adjourned.
Thank you.
Thank you, Judge.
Yes, sir.